And now, to address the legal concerns of the community, Praise AM 1310, 95.1 FM presents Legally Speaking. Here are today's hosts.
Good morning, everyone. I'd like to thank each and every one of our viewers, our callers, for listening to our show each week. And for all the folks I ran across this week, thank you for telling me about topics, and thank you for telling me about your interest in the show. We have today our superstar panel with attorney Milton from LA and attorney Vanita Banks from Chicago. We got so many important topics to deal with today, and so we're going to get right into it. But also, we're a live call-in show. Our phone number is 833-653-3529, 833-653-3529. Now, get started. The first topic that we're going to address today is the Crumley case out of Michigan. The father this week was found guilty of involuntary manslaughter. And so to refresh everyone's recollection of what happened, back on November 30th, 2021, the Crumley's 14-year-old son, Ethan, took a gun and killed 4 individuals at the local high school in this mass killing. And he pled guilty and got a life sentence as an adult without parole. The parents who purchased the gun for Ethan, even though it appears that he had a mental impediment or something going on, they were criminally charged, and they now both have been convicted. Now, the reason I bring this case up, particularly for my superstar panel, is that I've watched SWAT, one of my favorite shows with Shamar Moore, and season 7, episode 3, he came home and he showed you the correct way to put up your weapon. Milton, Vanita, he had this safe container that had a code. He put the weapon in there and it had like a double lock. I said, that's really impressive. Most people probably missed that, but if you want to avoid criminal and civil liability, I guess that's a good starting point. What do you think? Hey, Milton, take your,
What do we think about the putting away the weapon, or what do we think about the outcome?
First of all, the charges. In my practice, I've sued a number of parents for acts of their kids, but
Right.
And we've collected millions of dollars over the years for damages caused by teenagers,
Right.
particularly with guns. But none of the parents, in none of the cases I did, no matter how egregious negligent they were ever charged in a criminal case.
Well, I think if a parent gives a weapon to a young person or adult that they know have some mental difficulties and disabilities, I think if it's anyone give that type of person a weapon, there is some liability on their behalf that goes with that. I hate to think of this case being a precedent for the country, that anytime a parent gives a child a weapon, then they are strictly liable for what the consequence of the use of that weapon is by that child. Just, that's the law. I don't particularly agree with that. I think if you give a young 17-year-old just like you give them the car or a gun, I don't know that liability should just strictly follow that, Nate, without something else, without knowing that that person is reckless or a person is mentally ill or there's some mental problem there. That's my knee-jerk reaction to that. So I don't know what will happen with this case up on appeal because of that.
They're going to be in prison for a long time. Attorney Banks, there's one interesting thing, I know you're familiar with this case also, is that first, he was only 14 years old, and second, he had these crazy drawings and stuff at school that suggested he was going to go out and kill someone. Absolutely. So it wasn't the fact that he had this gun. It's that they purchased a gun for a 14-year-old. I'm thinking to myself,
Young, baby.
why are you buying a gun for a 14-year-old that could kill a lot of people, getting all these bullets? And it's obvious based on what happened that this kid has some pre-existing mental disease process.
Absolutely, Attorney Lee. I think that the facts in this case were dispositive, and we'll see whether or not it will become a precedent in cases moving forward. To your point, Attorney Grimes, but I think the facts in this case were so glaring, and you mentioned some of those, Attorney Lee, that the father bought the gun for this child who had exhibited gross signs of mental instability, that the school informed the parents that he had drawn these very threatening and just egregious pictures and that drawings, and that they refused to take him home that day. And so I think this case is fact specific, although I think it will be precedent that's used in future cases as we're addressing this gun violence epidemic that is a public health emergency in our country today. When we look at gun violence, it's the leading cause of death for children today. And you referenced the gun storage. Many states, including Michigan, have passed gun storage laws that require them to be kept safely to prevent injury. And so in this case, both the mother and father were convicted of involuntary manslaughter, which is the lowest homicide offense that you can be charged with in Michigan. And so it means that you were criminally negligent, and that these deaths were preventable and they were foreseeable.
May I, Nate? That's what I'm talking. I don't want to see a strict liability to parents because their kid do something and it ends up in harm to another person without some of those indicators involved. That's my concern. You said they'll be in prison a long time. Involuntary manslaughter, you could get probation for involuntary manslaughter out here in California. It does not necessarily mean you're going to receive a lengthy prison sentence. Voluntary manslaughter may carry a mandatory prison sentence, but not necessarily so. Involuntary.
There's 4 counts of involuntary manslaughter, and they face up to your point, Attorney Grimes, up to 15 years in prison.
What's the minimum? Up to is one thing. What is the range? I'm just saying in California. I haven't looked up this case. Can they get probation as a sentence?
Well,
possibly.
But the problem is, I thought when I looked at them, they've already been in jail.
Okay.
So
how long have they been in jail?
Credit for that.
Well, since 2021. So they've been in jail for a couple of years.
Yeah.
I would say give them credit for time served, double that. So 2 years, you get 4. 3 years, you get 6. I'm just saying that the sentencing is there's a range there that they could possibly, depend upon how contributory they were in that person's, what he did, what kind of sentence they get. They may
Well, wait a second, but here's the problem.
Let me say this, Nate, to address your point earlier. If this situation was not the situation here, but they live out in the boonies somewhere off of the freeway for 20 miles, and kids ordinarily have guns and they hunt and they use guns properly. You're saying that parent who gives a kid who doesn't have mental problems suffer the same consequence as a person who lived in a suburban area giving a kid a gun?
Well, I think that that's a totally different situation.
Okay.
In this case here, this kid had a demonstrated mental impediment.
Right.
Also, what she's
Right.
talking about, Milton, is 15 years for each homicide. So it's a total of 60 years potentially in terms of exposure, not just the 15 years. So, but each count, they got convicted of 4 counts of homicide.
Can they run concurrent?
Well, I don't know. I'm
Just saying, I don't.
when you have that much of harm caused to a small community, it has a devastating effect.
Yeah.
So community will be seeking justice and accountability. So I can't imagine an elected official that would give them a light sentence. I mean, when you have a crime of this magnitude, it's not just the harm to the people that are murdered, it also the mental aspect of people that were there who witnessed this, the emotional distress, of seeing your friends being mutilated by gun violence. So I don't know. I think that when you look at a crime like this, it's more than just the people that are killed. You have 4 people killed, people injured, and people that witnessed this, they lost their friends, the parents lost their kids. It's a devastating type of event that should not occur. But we do have a problem in our country. We're like, 3% of world population and got 50-some% of the private gun ownership. So we're one of the few countries in the world whereby everybody got guns. And I'm not against the Second Amendment. Lord knows I'm not against the Second Amendment, but I think we have to have better restraints. I think that here in our city, I see too much gun violence. I mean, last night, I woke up this morning, 4 people got shot in Broadway here in Indianapolis. You got one person who get upset about nothing, who make a big deal out of nothing, and then cause mass carnage. And so gun violence is a problem, and I think that we have to take it as serious as we can.
Absolutely, Attorney Lee. And this jury, many of them grew up around guns or have guns or own guns. So that's an interesting aspect of the case. Again, this case is very fact specific. And the jury took only, 10 hours of deliberation. And under the manslaughter penal code, Michigan penal code, manslaughter shall be, anyone committing manslaughter shall be guilty of a felony by imprisonment in state prison no more than 15 years or by a fine of not more than $7,500 or both at the discretion of the court.
And if I had a prediction based on the gravity of harm, the fact that it was a school, I don't believe that they'll get less than 30 years, Milton.
Well,
Interesting, Attorney Lee.
I never disagree with you, Nathaniel, but I do would like to see the sentence be appropriate to the crime and the involvement in the act, and it not just be based upon the death of 4 young people. I think our judges have a responsibility to uphold the law and not necessarily react and be influenced greatly by public outcry, because that will put everybody in prison necessarily if you have sentence be made by public outcry, because I don't think the public gives a damn about what the actual facts and the truth are. I didn't raise this boy. I don't know the things that these parents went through, but undoubtedly, if they tried to do the best thing they could for this child, you can bring up these school incidents and these drawings, but what were they doing to try to provide a decent living, a decent life for this kid? Did they tell him to shoot people? Did they say, son, this is the way you use the gun, and they gave him some instructions? I don't know what they did in parenting on this kid, but I do not support lynching them for the acts of their child without proper evidence.
Well, first, the father had the opportunity to take the stand. He decided not to. In the case against the wife, she did take the stand. I think that all the evidence that you're suggesting, Attorney Lee, should have or could have been introduced in the case. And I think that there's a distinction between strict liability and what was decided here, which was that the parents failed to exercise reasonable care and that they're criminally responsible because of their gross, reckless negligence in this case. And as you know, that's a different standard from strict liability. It wasn't just that they were the parents of the child and that they provided the gun to the child. It was all the things that the actions that they could have taken or omitted to take that led to their ultimate conviction by a jury of their peers in this case.
I know jurors or a lot of times, Vanita, are outraged by the blood and by the acts, and they may get off course of the law, what the law really requires in that situation. I had a case one time where the mother took her 6-week-old baby and put it under the car and drove over its head and crushed his head, and then came home and lied to her husband and said a black woman had kidnapped the baby. The jury found her guilty of second-degree murder, but the judge agreed with me on the fact that she had a mental illness called postpartum psychosis and reduced it to manslaughter, and then agreed further that she should not go to a mental hospital or prison, but be put in treatment. And she was in outpatient treatment for a number of years. The jury just could not accept the horrific act and the facts of that case, okay? So they could not, in my opinion, follow our experts and the facts that this young lady gave all examples of suffering from postpartum psychosis for weeks by pouring milk in the sink and water in the milk bottle and all kinds of abnormal acts that people witnessed, but they just didn't know what was wrong with her. So that's all I'm saying, is that jurors react sometimes to the events, but that's not necessarily what the law requires. And in this case, I don't know all the facts. I'm just leaving the door open that maybe the jury didn't hit it right. Maybe they did. Maybe you're right about these outrageous facts or acts. I don't know. I like to leave the door open for these people. If they don't deserve 30 years, Nathaniel, then don't give them 30 years because the public is outraged.
Okay, let's take a caller. Caller, Ms. Bridges, you have a question or comment for us today?
I have a comment. Are you there?
Yes, ma'am. Go ahead.
Okay. So, I'm listening, and I'm just like kind of blown away at the fact that there's a slight, discrepancy or disagreement in holding parents accountable for the part they played. Knowing their child, you don't raise a child for 14 years and don't know them. So knowing their child, whether they were rural or in a wooded area, didn't matter that the child is incapable of being responsible for a gun. If he had behavior and mental issues, there's no way that people's lives and safety should have been placed in his hands by the parents, thinking this child was going to be capable of making a sound decision with a gun. I care for my nephew who's autistic, and there's no way, he's 40, that I would go buy a gun and give it to him. Doesn't even make sense. Absolutely, the parents should be held accountable for every action and decision that they made carelessly. That's all I want to say.
Thank you for that, caller.
Yeah.
We respect your opinion.
Well, Milton, what do you think?
Every case is individual. You know, I'm not going to jump on it just because the kid did what he did, that the parents should be held accountable. I don't know all the facts. All I'm saying is that we should leave the door open. There's an appeal process, whether the Court of Appeal will uphold this, whether the Supreme Court will uphold this, I don't know. I am just saying I get concerned when people want to punish the defendants because of the death as opposed to the facts in the case. That's all I'm saying. You know,
Well, what about this, Milton?
It might very well be that the parents should be held totally liable. I don't know all of the facts. All I'm saying is leave it open to information. I don't have all that information.
Let's look at the reverse side of this equation. We have a high level of gun violence in our country, our neighborhood, by teenagers now.
Mm-hmm.
The teenagers somehow get the resources or revenue to purchase these weapons.
Yeah.
So at what point, what requirements should we put on parents for public safety? Should the parents monitor their kids' activities so that, or your situation about being on the farm and a gun, that makes sense. But in urban areas, should we have greater responsibility placed on the parents in terms of gun ownership and usage by teenagers?
I'd have to see the facts. Let me ask you this. Suppose the parents use that storage device or that system that you say was on, what was the SWAT. And they got a triple lock. They put it in a triple safe, one safe, another safe, and third safe. Now you can't get in it. It's got a lock, it's got a key lock, it's got a combination lock. Boom. This kid sat home one Saturday and bust all three locks and take the gun out. He's 16 years old and go out and shoot somebody. Are those parents responsible?
No civil liability in that case, because
That's
there's
a different
negligent
fact pattern.
parents. That case I wouldn't take. You know, I've
They
sued.
exercise reasonable care.
Yeah. So that they're not negligent. That's what they're required to do. So if the kid did that and go out and kill somebody, I wouldn't accept that case because I don't think that's negligence.
Okay.
On the other hand, if they left the gun underneath their bed and the kid knew the gun was underneath the bed, went out and killed somebody, I think that's negligence. On civil liability, we're talking different things now.
Okay.
I will make some real clear. I've always held parents accountable civilly for the acts of their kids. Our state law permits that, and your homeowner's insurance, most people don't realize that it's covered by your homeowner's insurance. Even when your kids get in fights and stuff at school or brawls, it's covered by homeowner's insurance. A lot of people don't recognize that. But so much for that. So our next topic that's been making the news, we got Georgia on our mind now. That's District Attorney Fani Willis. Maybe I lead off with our expert on this, Attorney Banks. What a mess down there in Georgia.
Absolutely, unfortunately, unnecessary or unfortunate distraction from the case, which is the strategy of the former president and other defendants in the Georgia RICO case. And we saw the judge rule this week that DA Fani Willis is not disqualified from prosecuting the former presidents and the other defendants in the case. And he held clearly what those of us who read the statute in Georgia, well knew that there is no conflict of interest in the case, and that she did not have a financial interest in the outcome of the case, which is an element of disqualification. He did also rule that there was an appearance of impropriety and held that either she or the special prosecutor, Nathan Wade, must withdraw from the case. And Mr. Wade tendered his resignation this week as well.
Well, a couple of things before we get started on this topic. The person, as it turns out, that created the evidence was his former law partner, Terrence Bradley, African-American, who submitted to the defense text messages on a regular basis against his client and his former law partner. I just thought that was such an odd set of events that didn't make a lot of sense to me. You know, it was bizarre. And as it turns out, all the evidence that the Trump team were using came from Terrence Bradley and his text. So I watched part of the trial. And so he's the one that gave them the theory. He's the one that gave them so-called evidence. And then when he got on the stand, he did not recall certain things or said that he didn't have personal knowledge of these events. And it was a weird thing to me because I was trying to figure out why would he place himself in that position in the first place. It didn't make a lot of sense to me.
Did the judge make the right call?
Well, based on, first of all, the fact that she had an affair with one prosecutor, I don't think should ever been a ground for disqualification. Our ethics rules even allow husband and wife to have cases against each other in different law firms. So in this case, the prosecutors were on the same team. But the second part about this, Vanita's salary her salary is what, $200,000 a year. She certainly is not a pauper. The point is, their allegations somehow, the charges were predicated on her making money through some lover is absurd. You know, this whole thing, to me, was a gigantic distraction. Now, does it hurt her credibility? Of course it does. But I thought, Milton, you might disagree with this, I thought it was a bad idea for her to take the stand. I think she filed an affidavit and let this matter go forward and try to reduce her personal involvement with this issue. I thought that she made a tactical mistake.
If she filed an affidavit, Nate, could the other side call her, though, to examine her on her affidavit, or she could just leave it with the affidavit?
Well, I thought, well, let's look at the scope of this whole process. They filed a motion for disqualification.
Right.
And so on the face of the motion, at the time they filed it, they should have produced evidence of probative value that support the allegation. When I looked at that, I thought that was lacking. So they make allegation without proof of the allegation.
But wasn't a prima facie case presented to even have this hearing in the first place, right?
I didn't think, well, you know, I didn't think so. I thought that he should have had them produce evidence by affidavit and say, what proof do you have that her going on these 2 trips somehow financially benefited her, who's making a salary of $200,000 a year? What proof do you have? I mean, it's absurd.
I didn't like the way that the judge conducted this case, to your point, Attorney Lee. Once it was raised, I think he had an obligation, because of the nature of this defendant and defendants, 4 of which have already pled guilty, by the way, in this case, that he may have felt like he had an obligation to address the matter. But 2.5 days of testimony, his approach, I have a problem with. Like you said, was there a prima facie case based on what was presented? And she could have filed an affidavit, which would have prevented her from being exposed now to the court of public opinion. But I also think that once they went down that road, that the testimony of Mr. Wade and of the former law partner were such that her testimony was needed. She kind of came in and saved the day, if you will. And you can talk about her demeanor. I'm not going to talk about her demeanor because one could maintain that she came in indignant and passionate and assertively maintained correctly and powerfully that she wasn't the person that was on trial, right? So we can have conversation about that. But I think that she adamantly defended herself. And I think she addressed those distracting allegations that never should have played out over, 2 days over national television. But I do think there's going to be some potential, implications as we move forward relative to, how this plays out in the court of public opinion.
I didn't keep up with it fact for fact, day for day, y'all. I'm sorry, but it sounds like the judge split the baby kind of like by ruling the way he did, trying to satisfy both sides a little bit and displease both sides a little bit. What do you think?
I think you're accurate that he was splitting the baby, but there was a couple other salient parts about this that bothers me. First, we saw in our own eyes the former President Trump attempting to create votes to overthrow the will of the public and the voting population in Georgia. We heard that. It was recorded. We saw Rudy Giuliani goes to the legislator, and what we found out later was factually untrue statements. We saw this with our own eyes. So there's a substantial body of evidence that would support criminal charges, a substantial amount. And let's not forget, we're talking about an assault on the United States democracy, not just a typical type deal where you go in 7-Eleven and steal a honey bun or something. We're talking about what we consider sacred, democracy in this country. So we saw that. So the question is, why is it relevant in the first instant of her having a boyfriend and they're on the same side? And for the life of me, the idea that they filed these allegations in the first instance to say that she got a financial benefit, and they point out that these 3 lawyers each got $650,000 over the last 2.5 years, whereas the Trump lawyers, they all made over $1 million in 6 months for defending the case. So, I'm thinking to myself, is nobody paying attention to this? This, to me, was such a major distraction. Now it's going to be on every news outlet. Go ahead.
I would argue that, well, the Trump lawyers made that, they put in those hours, but they're not going to get paid. They're going to get paid zero. We got the record of Trump paying people. So Trump lawyers are not going to be benefiting that greatly financially. And I'm entitled to prosecution by the law, not by the lovers. And I think that there is a certain amount of influence when people are lovers and decisions are made about my fate. So I'm asking the court to give me my right to a fair trial. and not have the prosecutor being influenced by public opinion as opposed to the facts and the law in this case, or nor be influenced by their bedmate. And so as the defendant in this case, Your Honor, I think that this inhibits my ability to receive a fair and impartial judgment from the prosecutor. And yeah. But you can throw up some argument for what they did and show their, romantic life together. I'm not saying it's prejudicial, but there is maybe some appearance of lack of fairness if these two are prosecuting me and they're lovers too. Yeah.
There's no evidence, and the judge flatly stated that their private life would in any way prevent the former president from obtaining a fundamentally fair trial in this case. But the whole strategy here, and it's very intentional, is to delay the cases, right? All of these cases, including this one, until after the November election, and to shift the focus away from the crimes committed in this case, the outrageous effort to overthrow the election, from shifting the focus from those crimes to gaslighting the prosecutors. And the strategy is just simply to create distrust in the legal process.
Okay, let me take a quick call.
The judge is saying there was an appearance of impropriety, right? Not actual impropriety, but an appearance.
He did say there was an appearance, and that's why.
That was a standard.
Okay, now caller, you have a question or comment for us. Also, one thing I need to point out, Milton, the Trump campaign, before we get to the caller, paid out $55 million last year to these lawyers. So you're right, Trump didn't pay it, but his donors,
they're getting paid,
appearing to be gullible, paid for this so-called billionaire's legal fees. So caller, you have a question or comment for us?
Hi, good morning, everyone. It's actually just a comment on the Fonnie Willis case. It's really not the Fonnie Willis case. It's the Georgia election interference case, and they just happened to drag her in it to interfere with it. But as far as that's concerned, Fonnie actually had to stay on this case. I don't see that judge wanting to be the judge that got rid of the district attorney that was going to protect Georgia voters' rights. He did not want to be that judge, excuse me. So he had to rule in favor of her, but he also was thinking, well, I got to give the other side a little something because she did, have a relationship with this prosecutor. So I think that was more in-house, like that should have been an in-house matter. But since the defense brought it up, they felt like they had to do something to look like they were cleaning up their own house. And so that's why he said, well, one of them have to go. And I thought Attorney Wade should have resigned before all of this because it was going to come down to him. They were never going to get rid of Fonnie if they didn't have to. DA Fonnie Willis. So that was inevitable, and this could have been stopped long ago, but they let it drag out, and now here we are. But it doesn't matter in the scheme of things. DA Willis is trying to protect voters' rights in Georgia. This man was caught on an audio that everybody can hear with their own ears. There's no misinterpretation, asking to revoke the rights of the voters in Georgia. So it's all going to die down eventually. Right now, it's tantalizing. People are bored, I guess. They're tired of hearing about Trump, so there's something else tantalizing, but it will die down. This was the best decision could be made. What I didn't like in his ruling, that he put all the extra in there to drag her personally. He didn't have to do that. He could have just made a ruling, said that, and left it at that. But he decided he wanted to put the extra in there, so he did. That was like her penance for, having that relationship. So now we move on. this case was probably never going to get heard before the November election anyway. I always said that. I said, there's too many defendants. This is going to take a long time. It was going to get heard after the election. So they delayed it another 2 months, but it really wasn't going to make a difference anyway. The only thing that matters is that this man gets prosecuted at some point for what he has done to the Georgia voters. And that's going to happen after the election, and ain't nothing he can do about it, whether he's elected or not, which I don't think he's ever going to get back in the White House. That's my personal opinion.
Okay. Well, thank you, caller. And we'll go to the next caller. Pierre Pullen, you had a question coming for us today, sir.
Yes, Nate, can you hear me?
Loud and clear.
Okay, yeah. Address the 6 charges that, to Renee's point, address the 6 charges that were dropped earlier this week. Will Fani refile them? I think she's so mad. I think she's mad as you know what. I think she's going to refile them against those guys and try to clarify that indictment. And for you, Vanita, I wanted you to comment on that Illinois mayor up there that's taking all of these lavish trips and first-class flights and using the money to just have a good time, or that's what she looks like, or is it justified? I mean, she actually is the mayor up there in that little Chicago town. But I'll take it off the air. Thanks for taking my call.
With respect to the 6 charges that the judge dismissed in the Georgia case, I believe she will refile those charges. And the court just stated that they should be asserted with more specific particularity. And so I think she fully well will refile those charges. And I'll address the mayor situation in the small town in a few minutes.
As a general rule, each state have statutes on refiling charges. And it's the same with civil cases. If you file a lawsuit, for example, and the case is dismissed on the pleading, you have between 10 to 30 days to amend your complaint. So, so dismissal of the charges is not the death knell to those charges. You have to essentially, you could re-indict the person to a grand jury, or you could file amended charges, I guess, by seeking leave of court or filing them. I'm not sure what their procedure aspect is. So I didn't see that as that big of a deal. Let me go to the next call real quickly. We got a lot of callers holding. Ms. Perry, you have a question or comment for us today?
Yes, I have a question. This doesn't have to do with the Georgia thing, and I'm politically illiterate. So Roe versus Wade, how can a law be in standing for decades, and then all of a sudden one court comes and decides it's no longer the law of the land? I don't understand that. How can they do that? I mean, how can you just overturn something when it's been the law for decades? How do you do that? How can a court do that, even if it's the Supreme Court? And isn't it against the law? If it's a law, I'm not trying to be stupid or anything, but and the majority of people in the country are not against abortion. So I don't understand. Maybe you could open my understanding to this. Maybe I'm confused. I must be. So somebody can answer that question.
Attorney Banks had talked about this exclusively. You want to respond to her? Oh, she's still on mute. Go ahead.
Well, there's a legal tenet that's called stare decisis, which means let the decision stand. And to promote clarity and consistency and uniformity in the law, It's unusual to reverse long-standing precedent. However, after over 50 years of Roe versus Wade being the law of the land in this country, the current composition of the United States Supreme Court ruled that that decision was wrong because there is no right in the Constitution to reproductive health care, and that was an issue properly deliberated and decided in the states. And so, unfortunately, from my perspective, because of the current court, which I can say in my lifetime, I never would have imagined that it would be as politicized and political as it is today. The court decided that that long-standing precedent that women and their families relied upon was not constitutional, and therefore they reversed the longstanding Roe versus Wade decision. I hope that's helpful.
And caller, one final note, the three judges who joined the Supreme Court gave testimony before the U.S. Senate under oath, and that they recognized Roe versus Wade as being the law of the land and good law. And so it appears that they made a dramatic reversal once they were given the statutory and constitutional authority to weigh in on this type of case again. The net result is that we've had utter chaos that followed this decision. We saw Alabama Supreme Court recognize embryo as a person. And so from a civil standpoint, it gives rise to civil lawsuit. In Indiana, for example, you could do a wrongful death of an unborn baby at 32 weeks or more. And so different state laws have different laws as to when a person become a person. But Alabama Supreme Court went off the deep end and said something that was so bizarre until it caused a dramatic disruption of services for in vitro fertilization, things like that. So you make a good point about the law in the sense that it should not have changed. But before I forget, Attorney Banks, you have an important election in Illinois, I think this week, correct?
Absolutely, Attorney Lee. Next week, March 19th, is our primary election. I just wanted to tell the caller as well, before I get to the details of our upcoming primary election, that Dalton Mayor Tiffany Hinyard, and we can talk about this in a little more detail next week. She's been accused of corruption, and the trustees have called for a federal investigation in actions that she's allegedly taken. And also, I'll just point out to the caller that when she was elected, she received 82% of the vote, but the tables have turned at this time. So we'll see what happens in that case with that mayor in Dalton, Illinois. In Illinois, and I'm looking, okay, this question addresses, the caller's question addresses something different, but our upcoming primary election is March 19th, next Tuesday, and early voting in Illinois can take place up through March 18th. You can early vote. So if you have not yet voted, please do. And you also can register on election day. And there are several judges that are members of the National Bar Association and that are running for re-election or for retention, including Joy Cunningham, Justice Cunningham, who is running for re-election to the Illinois Supreme Court.
Well, one of the outstanding judges there in Cook County Circuit Court is Judge Leonard Murray. Judge Murray has an outstanding background. You know, he started out in finance at CPA firm and later in private practice. Then he's been a judge for a substantial period of time. He was rated highly qualified, and he's running in the appellate court, District 1 there. So all the people up there, make sure that you look at the ballot if he's in your district, is Judge Leonard Murray. We certainly need such a skilled judge on the bench, making fair decisions for all citizens. And so make sure that you also, people in Chicago that listen to our show, make sure that you go out and vote. And because every election is important. The primary election, particularly in Illinois, is important because you have several contested races, and some of these races going to have some dramatic effect on your community. So make sure you get out there and vote. And I want to make sure that we also, I looked, Attorney Banks, my former law partner, John Fairman, looked like he's running unopposed. Is that still the case? Do you know?
I'm not sure about that, but that would be great.
Well, I checked the ballot earlier this week and I didn't see, I got to ask him whether or not he's got competition for the race. I don't know. I'll call him today because I've been trying to monitor that because, you know, we certainly need John Fairman in that circuit court seat there in Cook County. And but back to this Trump issue before, we have a few minutes. We have seen ourselves, January 6th, we saw in real time an assault on American democracy. Everybody saw that. And it was done by, we all know who was behind this attack on our country. Only a couple times in American history have we seen an attack on the United States government. But January 6, 2021 was certainly qualified as an attack on democracy. Almost 1,000 people have been charged for participating in a takeover of the Congress. And so when we're thinking about voting this fall, you got to remember that when we say every election is important, this year, there's so many important issues that affect your daily life that are important. We have, it's not just abortion, but we've had an attack on affirmative action. You know, just recently, the University of Florida got rid of all its diversity employees. And the NAACP, for example, council calls for a boycott of University of Florida. But I thought that the people that need to boycott are the kids on the football and basketball team that generate $150 million a year in gross revenue for the university. That will get their attention. The idea that they think that they will get rid of diversity would go unnoticed based on that governor in Florida. So there's a lot of important issues that we need to pay attention to, but it won't matter if you don't vote or serve on jury duty. It's your duty.
Absolutely. The most two important obligations of American citizens to vote and serve on a jury if you're called. And so we see that what can happen when we don't vote. We see the three appointees that the former president made to the U.S. Supreme Court, which is a result of their decision in reversing Roe versus Wade, young women in this nation today have less rights than their parents did in this country. And so another very critical reason why voting matters.
Yeah. Any final comment, Milton?
I think the last caller illustrated the importance of voting, and she faced the fact that she says she's ignorant about our political situation. We can't afford to be ignorant about our political situation. We got to go out and vote. Your vote will affect the political situation that you are lacking of understanding in. So go out and vote.
Well, thank you, callers, for sharing the information with us. We'll look forward to talking to you next Saturday. Until then, may God bless and keep you. And keep the faith and make sure you get registered and go out and vote. Thank you, everyone. Have a blessed day.
Bye-bye.
Thank you. God bless you.